for Yamam Akraba Ediba #1 channel. News are so any day epa ewo mining mu yoko near Oshana Pana Yasone so na Edia Brum na mate nsem so any day epa ewo mining na emu ni nsem ni bu ho na se ebeto dwa emu eyedu se ebet na se na ya ka edia mamute no de mamko ewo kotie nsem so any day epa ewo mining na se eba ye ka ho na de so edia ma yahwehwo.
Just hearing also that a decision has been taken on the substantive matter that the ຄຼHOCKING MP sent to court. I'll bring in now our court correspondent, Lord Eduasare, to share a bit more on that development. Lord, talk to us. What is the decision that the court has taken on the ₦HOCKING? Oh, it appears Lord cannot hear us at the moment, but what we are hearing is that the Supreme Court has thrown out that case seeking to injunct the president from forwarding the petition to the Council of State. Essentially, we've been telling you how the ₦HOCKING MP are taking the matter to court, asking that the Supreme Court overrule that process the president had kickstarted. This moment, we're hearing from the Supreme Court that the matter has been struck out completely. What that means for the process, we'll find out from lawyer. But let me try Lord again to give us a bit more from what has happened in court today. Lord Eduasare, talk to us. The Supreme Court, we now know, has struck out this matter. But tell us how proceedings went down today.
So we need to put things in perspective. You realize that the ₦HOCKING Member of Parliament, Vincent Assefuwa, he had two injunctions at the Apex Court. The first injunction had to do with injuncting the president from forwarding the petition to the Council of State. Now, that petition or that injunction has been withdrawn by his lawyer, ﷺ, and has been struck out as withdrawn by the Apex Court. So it's just one of two injunctions that has been struck out, not the entire substantive. The second one, which is the crux of the case, is now being argued out as we speak by the former Attorney General, who is the lead counsel for Vincent Assefuwa, which is ﷺ, and then the Deputy Attorney General, he is representing the Attorney General's office today. But early on, the former Attorney General was objecting to the presence of the acting Chief Justice, Justice ΒREAKING, from presiding the reconstituted panel, which consisted of four others, Justice Emmanuel Kulendi, Professor Henrietta Mensah-Bonsu, Justice Gewu, and then Justice Amadou Tanko. Now, this was not the original panel hearing the matter when it was first called. You recall that, and if you see the list now, you realize that 3 justices have been reconstituted. At the last time agenda present, we were told that for an unavoidable reason, they had to adjourn the matter today because one of the sitting justices on the matter, Justice Samuel Sedu, who we now have gotten to know that he was a member of the committee set up by the president, was absent, and so the case was adjourned today. So we came today and realized that the entire panel has been reconstituted.
I see. So let's slow down for us. Two things have happened in court today. The first one being the Supreme Court not agreeing with the former Attorney General that Justice ΒREAKING should excuse or recuse himself from the empaneling of the justices or even empaneling himself. The second matter, which we're just hearing, breaking this minute, is that the Supreme Court has thrown out one of those cases. Explain the case that has been thrown out to us.
So what has been overruled was the objection by the former Attorney General, one, asking the acting Chief Justice ΒREAKING to recuse himself, and then 2, objecting the entire reconstituted panel from sitting on the matter. He argued that the original panel should have been sitting on this matter. Now, what has just come in is that Vincent Assefuwa, led by ﷺ, has withdrawn
or any for some so any the eba our man and our so a good so witty measure say witty na adventure or a fancy moja a fair Eddie mammy our comment session for young queen young good tea in yet was
one one of the injunction suits, you stated that the first injunction suit had to do with stopping the president from forwarding the petition to the Council of State, which at this point is moot because the Chief Justice, Justice Torkornoo, has been suspended at this point. The second matter is what is still being argued on, and so that is a substantive case, and so that there's no decision to that as we speak because the Godfrey Obadame just finished making his arguments, and then the opposition is being made by the Deputy Attorney General, Justice Semsai.
Lord, I appreciate the clarity and reporting. Thank you so much for talking to us. Lawyer Kpebu is still with us over the telephone. Lawyer, this would appear a natural progression of the case, considering that the president's, attention to the matter has gone past forwarding the issue to the Council of State. Would you say?
Absolutely, Kamini. Absolutely. So you got it right. His application, or let's say, Research Assefu's application had become moot because in the interim, the president had given the Chief Justice an opportunity to respond, and even after the Chief Justice responds, the president did the hearing and did the which led to the prima facie determination. So it means that it's too late in the day. Nothing can be done. What he was seeking has already been taken care of. That's how come. So you hear that he withdrew the application, meaning that as a lawyer, if you see that your application has been overtaken by events, what you do is that you call it back. So it means that you don't try to convince the court to grant it. No. You just withdraw. So that's what was done, and that's the right procedure. So now that they are dealing with the substantive matter, that's good. It's good that the Supreme Court is going to the substantive matter today so that we can get a judgment on it, and then we can take it from there. Okay.
I see. And then also we can say that this incident may or may not be a pinhole to what the outcome of the substantive matter will be, right?
No, because his main contention was that the president must give a copy of the petition to the person involved, so that the Chief Justice, and get a response, okay, before passing it on to the Council of State. So now that has already, they've gone past it and all that. No, I mean substantively. So now the court will rule, okay, the court will rule whether in future, when such matters happen, you must give a copy to the respondent, etc., before the Council of State, is asked to weigh in. So let's see how it goes.
Indeed. Who is private legal practitioner. He joins us for a bit more on this. Good afternoon to you, lawyer. But here we are, that objection raised against the impaneling of the justices with the acting CJ at the top has been thrown out of court. Your thoughts on it?
Yeah, so that's the right decision that the court is taking, right? It's the right decision because, number one, when it comes to the objection, Justice Bafuboni is acting Chief Justice because the Constitution says so. Let's be very clear. It's the Constitution that says that when the Chief Justice is not in office, the most senior Supreme Court Justice becomes the acting Chief Justice. So to say that Justice Bafuboni has an interest in the case is something I'm struggling to understand. His appointment is constitutional. It didn't take President Mahama to appoint Justice Bafuboni. No, nothing. It's automatic. I'm in court right now. I don't have the Constitution here. I would have read out the provision. But it just goes automatically. So once Chief Justice Torkornoo was suspended, automatically it went to Bafuboni. It didn't take President Mahama to appoint him. It didn't take any ceremony. It's a constitutional appointment, straight, without any person having a hand in it. And the Supreme Court has been clear. There's a number of decisions, okay,
right,
that shows that if the Chief Justice must do something, you can't use these objections to disqualify the Chief Justice, right? So the way he raised it, that objection was bound to fail.
I see.
And,
Lawyer,
and
we're just here. We'll see how that goes. Thank you so much for talking to us. Martin Kpebu is a private legal practitioner. We've just been hearing from the Supreme Court that the ĽTAFO MP has withdrawn one of 2 cases.
Now, staying on matters relating to the court, the Criminal Court 4 has granted the former secretary of the Inter-Ministerial Committee on Illegal Mining, Charles Peace, and one Andy Owusu bail in the sum of 200,000 cedis each. The special prosecutor earlier slapped 15 counts of corruption charges against them, accusing them of abusing public office for personal gain in connection with illegal mining operations. In the first count, Mr. Bisu is accused of using his public office for profit, contrary to Section 179CA of the Criminal Offences Act 1960, Act 29. And the court granted each accused person bail, like we mentioned, in the sum of 200,000 cedis with 2 sureties, one of whom must be justified. We know that as part of the bail conditions, the passports of both accused are to be deposited with the registry of the court. They are also to report to the OSP once every month. The matter has been adjourned to the 29th of May 2025 for case management conference. The court sat on the case to take the plea of Mr. Bisu. Let's take you there right now. Christian Yali is joining us with a bit more on the details from the court. Chris, what transpired in court today? We know we've been getting bits and
for anything for her and I'm going to be so fair. I was at a 7 show and not a from your heart. I cannot tip so much crown.